And I'll tell you a little bit about, I sort of would couch some of my remarks in the context of my own experience and things that I found in working at the University of North Carolina, which, as you probably know, most of the students come from North Carolina as required by state law. We have a small number of out-of-state students. It's very hard to get in from out of state, so those students are typically quite exceptional. So we see a lot of very able students at North Carolina, but sometimes I'm surprised at things that they perhaps haven't really thought about or haven't been exposed to, some really basic ideas. And so I can't really give you, I mean, I like Professor Kabilka, I teach a class on civil liberties and civil rights. So we can't really, cover everything on civil liberties, but we can talk about some important issues that I think are maybe helpful to keep in mind when you talk to your own students. So I think history is an important guide. So let me start with a little bit of history and a little definition of terminology. When we talk about civil liberties, I mean, I suppose most people have an idea in their head. They think about certain rights that people have, but I usually think of them as limits on what government can do. So when I talk about my class on the Constitution, I talk about things in that first class, things that government may do. So Congress can tax, regulate interstate commerce. There are certain powers that are allocated to the national government. So there's a list of things that can be done. And then the Bill of Rights sort of covers the things that cannot be done, the prohibitions, the things that government can't do, or alternatively, things that government must do where there's no discretion. So really, when we talk about civil liberties and civil rights, we're really talking about prohibitions on governmental power, things that explicitly limit what it is that government can do. Now, what's funny is that I think mostly our students, at least my students anyway, sort of take the Bill of Rights for granted. They just assume that it's a natural part of what the Constitution would consist of. And I suppose first thing I'd point out is it's not at all inevitable that the Constitution would contain an explicit Bill of Rights. And in fact, although we tend not to think of it, they were tacked on at the end after the Constitutional Convention. And so I suppose we might ask ourselves, why were there no Bill of Rights? Why was there not a Bill of Rights provided in the original Constitution? I mean, I think a lot of people, if you ask them what you think is great about American politics, American government, they'd say, well, it's majority rule with minority rights. But the rights that people think of as so important were not explicitly provided for in the original Constitution. Now, there's some reasons for that. And one is pretty obvious. That's not why the framers of the Constitution met in Philadelphia in 1787. So one of the things I try to emphasize for my own students is to remember that the whole purpose of the Constitutional Convention was to strengthen a government that was obviously not functioning. So the Articles of Confederation that existed from 1781 to 1787, it was sort of consistent with the principles of the American Revolution, which is to say, they were very skeptical of strong central government. They didn't like the idea of an oppressive authority far away, exercising power arbitrarily. So that was all well and good, but in terms of the practical operation of the Articles of Confederation, simply didn't work. It was not really anything like we would think of as a national government. I suppose the thing that I make it analogous to today is something like the United Nations, where you have a group of nations, in this case, states, that come together to form a kind of mechanism for governing, but they don't give up any power. They are all each individually sovereign. And so a number of practical complications arose that showed the weaknesses of the Articles of Confederation. And so the purpose of the convention was to say, how can we remedy the articles? How can we make the national government stronger? So they are there thinking about how do we invigorate power at the national level? Principally, Congress, under the Articles of Confederation, didn't have the power to tax, didn't have the power to regulate interstate commerce. Those two powers in particular made it quite difficult for the national government to operate. So they're there not to limit government, but they're there thinking about how do we strengthen government? How do we make it more powerful so that it can regulate a lot of the what turned out to be economic problems that were wrought by the Articles of Confederation. So they're thinking about how do we make the central government stronger, not weaker. Now, at the same time, though, there were individuals that were very skeptical of the concentration of power. They were worried about states giving up their power and placing it into the hands of a national government. And this is also something that I try to emphasize to students, is that if you were alive in the late 18th century, you were much more likely to think of yourself as a resident of a state than as a resident of the United States. So you're more likely to think of yourself, in my case, as a North Carolinian, as opposed to an American. That concept would have been, in some sense, very foreign to them because they didn't have this national consciousness. So the states are being asked to turn over power, at least some power, to the national government. And so a lot of people are, I think, justifiably concerned because they don't know what's going to happen. We're giving up power, turning it over to this national government. It's going to be able to do things from some faraway place, a distant group of representatives that doesn't necessarily know or is familiar with local conditions. And there's a great concern that it will exercise power arbitrarily. And so naturally, there are folks like Thomas Jefferson. Jefferson now was not a member of the convention. You might recall he was away serving as ambassador to France, but he's arguing strenuously from abroad to his friend and fellow Virginian, James Madison, that there needs to be explicit limits placed on the national government. We need to say, here are the list of things that the national government cannot do. Felt that that was a basic fundamental guarantee that citizens were entitled to. Now, part of the answer came from people like Alexander Hamilton and James Madison. Their argument was that you don't need a Bill of Rights for at least a couple of reasons. One is, we already have said what the national government can do. Congress can regulate interstate commerce, power to tax, power to declare war, the power to coin money. We list the things the government can do. And so we don't have to say a list of things that government can't do, because it's not on the list, then Congress can't do it. The example I sometimes will give to students is one they're familiar with. At least in my case, I can remember taking math tests in school and the teacher saying, you can bring a piece of paper with as much as you can write on both sides. So it wasn't an open book, open notes test, but sort of as much as you could cram onto a piece of paper. Now, did my teacher have to tell me, you can't bring a book, you can't bring a friend, you can't bring a smartphone? Do I have to come up with a list of all the things that you can't bring? No, of course not, because I've told you what you can bring, and by implication, I've excluded everything else. So people like Hamilton and Madison are saying, we don't have to say that Congress can't regulate speech or Congress can't regulate press, because it isn't given any power to do that in the first place. So part of their argument was a matter of logic, is that we don't need a Bill of Rights because by enumerating power, we have limited it. Also, I think just as important, you had people like Hamilton and Madison that didn't put much faith in a Bill of Rights to begin with. They had experience at the state level, and they saw that while states had bills of rights, they didn't seem to serve as much of a barrier to oppressive majorities. So in their practical experience at the state level, their view was states that have bills of rights, it doesn't really matter, because if you have a group of people that really are intent on imposing their will, Bill of Rights isn't going to stop them. So their answer was separation of powers, dividing authority. We spread it out and we make sure that each branch can't do anything much without the help of the other, and that you get the support of the other branch to achieve your policy goals. So their answer was, we have enumerated power, that's limited it, and we've separated power, and by separating it, we have sort of diffused it. The old example that I was taught, I'm not sure it's of much relevance now, was the idea of people sitting around with a bottle of wine. If one person drinks all the wine, they're going to get intoxicated pretty quickly. But if we pass it around amongst a number of people, very unlikely that any one of us is going to get sort of wild ambitions. And so the argument here is that we spread power out, we make it difficult for anyone to sort of become intoxicated with their own authority. we make it hard for power to be abused. So people like Hamilton and Madison said, we don't need a Bill of Rights because the Constitution already is going to serve that purpose for us. Ultimately, though, as you probably know, the way history played out, it was seen, and Jefferson sort of won out the debate, and the argument was that we will, in effect, throw our support for ratifying and continuing to support the Constitution, but only if you set about developing a Bill of Rights. So James Madison, one of his first tasks as he was elected to Congress, was to come up with an enumeration, an explicit Bill of Rights. Madison, ironically, who wrote the Bill of Rights, wasn't a big fan of it. He, in fact, I think he later described it as a nauseous task. I think that was a direct quote. Wasn't particularly keen on it, but he knew that it was a kind of political requirement. So he said, where am I going to get this contents for a Bill of Rights? And so there are a number of historical influences that we might point to. The Magna Carta, which contains elements of due process, the English Bill of Rights, which contains things like the guarantee against cruel and unusual punishments, but also the state constitutions at the time had a whole bunch of individual provisions from which Madison could draw. So Madison comes up with a list of possible ways in which we can limit principally the national government's power, and that's the goal. Remember, the answer here is to respond to people like Jefferson that are worried about states giving up power and the national government taking on too much power. So here we've come up with this list of explicit limitations. Now, that's the way it was understood, at least for up to the mid part of the 19th century. A case called Barron versus Baltimore, which you might be familiar, was a prominent test of to whom does the Bill of Rights apply. You had a man who owned a wharf in Baltimore that was ruined by some infrastructure improvements, and that led him to sue Baltimore to say that you have violated a provision of the US Constitution, what's called the Takings Clause of the Fifth Amendment, that requires that when government takes your property, that you be provided compensation. He said, look, Baltimore has ruined my wharf. They've taken my property. I think I should be compensated. And the court's view was, sorry, you need to look elsewhere, not to the US Constitution. The Bill of Rights only limits what Congress can do. This is really important. An important point that students, I think, sometimes miss is that for much of the history of the United States, the Bill of Rights limited only the national government. And so what we think of, if Professor Kabilka and I had to teach our class on civil liberties without the Bill of Rights applying to the states, it'd be a pretty short course, because most of the cases involving questions of oppression by individual groups, sort of majority or minority tyranny, it arrives at the state level, where people are more likely to be like one another. This is one of the things that Madison warned against. If you remember Federalist number 10, he said, what you need to worry about is homogeneity. You need to worry about people being like themselves. The more people share common interests, common attributes, common backgrounds, the more prone they are to want to exercise their authority over those who are different. And his argument was, at the national level, the nation is physically so big, composed of so many different types of people, it's going to be hard for them to organize and exercise their authority in an oppressive way. So for much of the history of the United States, there isn't much really going on with the Bill of Rights, because for the most part, the national government wasn't legislating as much as it does now, but it wasn't exercising it in a way that we would think of as ways that would call the courts to legislate much over those issues. Now that all changes in the mid-1900s. Justice John Marshall Harlan had been arguing for a long time that one of the Civil War amendments contained the Due Process Clause, which said that no state can deprive a person of life, liberty, or property without due process of law. And basically his argument was that phrase, that no state could deprive a person of life, liberty, or property without due process of law, that the liberty that states couldn't deprive you of were those fundamental rights in the Bill of Rights. So his argument was that the 14th Amendment, the terminology is incorporated, but basically reached out, grabbed, and made everything now binding on the states. So his argument was federalism changed a great deal after the 14th Amendment was put into the Constitution, because by his logic, because there was a due process clause that said states can't deprive citizens of their liberty, his argument was, what is that liberty? It must be the stuff that's already in the Constitution, those basic rights. Now, Harlan's view was not adopted by his colleagues, but ultimately, a few years later, the court began to adopt it in a kind of more modest fashion. Benjamin Cardozo, in the case Palco versus Connecticut, the court said, you know what, much of Harlan's argument is in fact accurate, that the Bill of Rights does apply, at least some provisions of it do apply by way of the 14th Amendment. And what we're going to do is decide case by case whether a provision of the Bill of Rights is so fundamental that it is part of that liberty protected by the due process clause of the 14th Amendment. As I'm sure you know, basically every provision of the Bill of Rights, almost every provision, is now binding on the states. Because of that, I think you have a kind of a great change in the way, at least the job that Professor Kabilka and I do, because as I mentioned, most of the cases that involve, not all, but on balance, most of the cases that involve questions of civil liberties and civil rights that come before the US Supreme Court start at the state level rather than the national level. So one of the things I always try to emphasize is that there's a certain amount of truth that Madison recognized, that people who are like one another tend to be skeptical of those who are different. And hence we see most of the cases coming from state and local government. Okay. It's sort of hard to say what the Supreme Court does and does not do in cases of civil liberties. What I want to do is highlight what I would say are some basic themes, or maybe some generic rules that I would say hold most of the time. And I think they're really helpful for sort of making educated guesses about how the court is likely to approach certain areas. So I want to give you these couple of basic rules, and then I want to illustrate them in a couple of different policy areas, and then we can talk about whatever might interest you. As I say, it's hard to generalize because what the court has done with regard to civil liberties and civil rights, it varies a lot from over time, and from issue to issue, it's not always the same. But there are some, I think, important takeaways that you see fairly consistently, and that is the Supreme Court tends to be very skeptical of actions by government that discriminate. And when I say discriminate with regard to civil liberties, I'm talking about singling out some particular idea. It can be an idea expressed in a newspaper, it can be an idea expressed through speech, it can be a religious idea. But if you single out some particular idea for a burden that you don't place on other similarly situated ideas, the court's usually going to look at that with a fair degree of skepticism. So anytime government singles out something, some idea, some view, some perspective for a burden that it doesn't place on others, the court's usually going to say, tell us why you have to place a burden on this, but not other things. And the court's usually going to be a hard sell on those types of issues. The other related takeaway, I think, is that the court is usually prone to allowing people to exercise liberties when there isn't a tangible harm. That is, the court will often accept the actions of government if it's convinced that what it's doing is actually stopping something bad from happening. So if the court is faced with a case in which there isn't necessarily some type of public disruption, some type of violence, here I've given an example, interference with national security, the court will typically say, well, unless there's something terrible that's happening, then we're not convinced that we need to allow you to exercise power in a way that limits that liberty. Now, again, I don't think you're going to find those written down in a textbook saying, here's the Supreme Court's generic rules. But I'd say if we step back and say, what sort of general tendencies do we see emanating from the court's civil liberties decisions? It's that if you single something out, the court almost never will allow you to do it unless it's convinced that something really bad is going to happen as a consequence. So let me take you through just a couple of illustrations to talk about how I think you can see these rules played out. Here are a couple of cases that involve the issue of religious liberty, and I think illustrate the court's approach to that. Two cases, two different outcomes. The first is a case, it's sort of a mouthful. It's called Church of the Lukumi Babalu I versus the city of Hialeah, Florida. Now, what that case involved was a Cuban religion that has its roots in Africa, a religion called Santeria. It's found, there's not many adherents in the United States, but most of them are concentrated in Florida, given its proximity to Cuba. It has elements of Roman Catholicism to it, but what became an issue in this case was that they involve animal sacrifice. So they sacrifice small animals, chickens, doves, turtles, goats. And when they announced plans to come to Hialeah, Florida, basically the city went into a panic. They had an emergency meeting and said, how do we, basically said, I mean, didn't basically, they were on record as saying, how do we stop this church from coming to town? So they passed an animal cruelty law, and they also passed laws having to do with the disposal of what they called organic garbage. And at the same time, they made lots of exceptions. Exceptions for who? Basically everybody else. So it was animal cruelty to kill an animal, but it wasn't animal cruelty to go out and hunt an animal. A lot of hunters in Texas didn't want the law to apply to them. Those that prepared food religiously, like Orthodox Jews that kept kosher, they were exempt from the law. It was basically a law which treated the Santereans in a special way. And the court said, tell us why it is that you have to single out this particular group to the exclusion of others. If you want to deal with organic waste, pass a law that deals with organic waste. You want to deal with animal cruelty, pass a law that deals with animal cruelty. But what the city did, and what the court found problematic, was singling out the Santereans for a special burden that wasn't placed on others. Now, you can contrast that with the other case, Employment Division versus Smith, that involved members of the Native American church that wanted an exemption from Oregon law to use peyote as a part of their religious celebration. So peyote is, it's a hallucinogenic that's derived from a cactus plant, and its principal ingredient is mescaline. And so members of the Native American church were taking it for legitimate sacramental reasons. And the question in the case, it's slightly more complicated than I'm going into, but what the court wanted to know was, did Oregon law have to make an exception for the sacramental use of peyote? And the court's answer was, well, no, it doesn't. Why? Because this law wasn't passed to single out the Native American church. Oregon had passed a law which regulated a variety of dangerous substances, of which peyote was one. It was, the court's words, a neutral law of general application. It's not religiously based, it applies to everyone. And so in that case, the court's concerns were easily satisfied, because in that case, it was not singling out a religion. It was simply passing a general law of dangerous substances. You get the idea here. So I can go through the others a bit more quickly. Singling out a particular idea with regard to speech, most people know the case of Texas versus Johnson. That was the flag burning case. So 1984 Republican National Convention, a young man that was protesting the Republican Party convention burned an American flag and was prosecuted under a state law that forbid desecration of the flag. The court's decision in that case was that Texas basically had allowed people to use the flag to only express a single idea. That is, you could wave the flag in a patriotic fashion to say good things about the United States, but Texas had denied the opposite, which is the right to burn the flag to say maybe negative things about the United States. So in effect, the court says, you might be able to deal with, let's say, maybe someone wants to have a, here, if I wanted to burn something out of my front yard, I suspect the city might have something to say about it, but they're not concerned about what I'm saying when I burn it. The court's view here is that what you can't do is to single out a particular use of the flag for a limit that it doesn't place on others. That contrasts with this case, US versus O'Brien, which is decided well before. It's a Vietnam era case, where you had a number of individuals that were protesting the Vietnam War by burning their draft cards. And there, the court was willing to allow the federal law to be applied against those who burned the draft card, because the reasons for prohibiting the destruction of a draft card didn't have anything to do with speech, which is to say, the government argued there's a reason we have people required to carry a draft card, because it tells them their draft status, where they go, where to report, what to do under the circumstances that they are called into service. And so the prohibition against its destruction, the court upheld because it wasn't out to get a particular anti-war message, the way the court saw by distinction in the flag burning case. Sometimes, though, the court is also concerned with harm. Sometimes those harm cases are easily satisfied in the school context. A couple of cases, I see I have the wrong case. I wrote Tinker versus Des Moines 2011. That's absolutely not correct. I'm sorry, I'll fix that for you. And neither is Bethel School District versus Fraser. Bethel School District was, I think, a 1986 case. Tinker was 1969. The dates aren't as important as the issues. Bethel School District involved a young man that gave a speech at a class, what would you call it? Student government, where we elect people to run, people run for student body office. And Fraser wasn't running for office, but he was nominating a friend of his. And he gave a speech that it wasn't, I would say, dirty, but it was filled with sexual innuendo. So he talked about, his friend who was gonna, that he takes a point and nails it to the wall and he pounds it in, and he attacks things. He doesn't do it in spurts. Sort of sophomoric stuff you would imagine that someone might say if you were, in high school. And he got in trouble, was expelled for it. And he argued that his right to freedom of expression had been violated. And the court's answer was, the school has a right to promote the appropriate learning environment. And if it interferes with that environment, in this case, as it had, because the school said this is inconsistent with our values, there were people that were yelling and hooting, and some students were confused. Basically, the court said schools have to deal with these types of disciplinary issues, and it's not because they had something against his message, but rather it was the disruption, the harm from the school day. Now, in the famous Tinker case, so famous that it's lived on to 2011, the Tinker case, of course, involved the use of the armbands to protest the Vietnam War. And in that case, it was a case where the students were told that they couldn't come to school. They would be, they'd be told that they would, they were told that they would be suspended from school if they wore these armbands to protest the Vietnam War. And the court was skeptical of that, in part because it singled out a particular idea, which is to say, the school said, we're not going to allow you to wear an anti-war message, but it allowed people to wear other things, campaign buttons, t-shirts, and all the rest that people wear. So the court basically said, why are you singling out this one particular message for a burden? And the school's answer was, well, it's disruptive. And the court said, was it in fact disruptive? And it turned out there was no indication that it posed any particular problems. The court wasn't convinced that there was any disruption or problem that had to be dealt with. So in the Fraser case, you have disciplinary problems. In the Tinker case, you do not. And so the court doesn't see harm in one case, but sees it in the other. Last example I'll give you is something which come up more recently as a function of modern technology, talking about harm, this case not from speech, but from the press. A couple of cases that argue for damage that comes from certain types of media. One case is a case called New York versus Ferber, that was a challenge to a New York law that outlawed the possession, sale, distribution of child pornography. And you had an individual who was arrested for selling, I think it was some films of young boys in sexual situations. And he argued that this was basically freedom of the press, that the person who made the film might be exploiting children, but once the film was made, that it was sort of, in a sense, the argument was, it was victimless, that I'm simply sharing this information with others who have the right to buy it if that satisfies their emotional needs. And the court's view was child pornography needs to be dealt with root and branch. And so we go after and allow government to deal with all potential harms that emanate from it. And that includes selling it, because when you can sell it, it creates an incentive to create more, and buying it, because when you buy it, that means that people are out wanting to purchase more. And it also creates, as the court said, a kind of permanent record of child abuse. And so the court has no difficulty dealing with a free press claim because it sees a substantial harm from the presence of child pornography. Now, that's different from the more recent case called Brown versus Entertainment Merchants Association. The argument here was a concern also about children, not from their exploitation through pornography, but rather through their exposure to violent video games. And so the state had brought forth evidence which suggested that psychologists had demonstrated that violent video games exacerbated violent tendencies among young people. And so that what they wanted to do was to make it a crime for individuals to buy, individuals of a certain age, below the majority age, to purchase violent video games. And the court's view was, in this case, it did not necessarily see a harm from young people being exposed to this type of material, which is to say, the court said there's lots of violent things to which young people can be exposed. There's lots of, I think the court, sort of, there was some discussion of comparing it to Grimm's fairy tales where, the witch throws young children in the oven and burns them alive. That sounds pretty violent. Here we have similar things. The court's view was that this was a way of telling a story the same way other types of media convey stories. And the court wasn't convinced, I'm not trying to convince you, I'm simply saying the court wasn't convinced that there was a sufficient harm there, that young people needed to be prevented from purchasing that information. So all I'm suggesting here from these two cases is, in one case, the court is easily persuaded that something bad is happening, easily persuaded about the harm from media. In the second case, it's not. And so if the court perceives a harm, it's going to be more easily convinced. Okay, those are those quick examples I gave you. Where is the court going to go with civil liberties in the future? A lot of discussion now in the media from people that follow the court and think about it, saying, well, is the court going to change? Is it going to radically scale back? Is it going to move forward in some areas? I think we usually get overexcited whenever there's a change in the court. We imagine there's going to be radical departures. They said that when Warren Burger became Chief Justice, there was some expectation that maybe Rehnquist would change the direction of the Burger Court, which was pretty liberal, not as liberal as the Warren Court, but held by a lot of its precedents. I think the court isn't likely to abandon long-standing precedents, and those broad principles of being skeptical of discrimination and looking at harm, I think those sorts of things are kind of constants that the court is not likely to back away from. What you are more likely to see, I suppose, is the court kind of nibbling away at this or that policy, sort of nudging policy in one direction or the other. I suppose the one area where the people who follow this think you're most likely to see a change is greater protection for religious liberty. A lot of cases aren't necessarily being decided by the court, but a lot of emergency orders, I'm sure you might be familiar with them, where people complain that outdoor gatherings were limited to a certain number. That number was higher for some, smaller for churches, and that the number ought to be the same for all. Those sort of emergency orders came before the court. I think a lot of people think that presages the court returning to a time when it might have been more skeptical of passing general regulations that might affect religions adversely. I think there's also a concern that the press might have a tougher time. I think I don't know how seriously to take it, but there are individuals that are talking seriously about the need to regulate things like Facebook, or the need to make it more difficult for people to sue for libel. I think both of those are sort of policies that are on the horizon. And even if the court isn't looking to change those issues, whenever government starts regulating them, inevitably the court's going to be drawn into those challenges. So the court certainly plays an important role, but obviously policymakers are going to be working in this area too. So we'll have to wait and see what happens.